Greetings to you viewers from across the globe. You're welcome to the show Viewpoint, where we discover perspectives and embrace dialogue. I'm Odiawa AI for Veegil Media. On the show today, we will be talking about the Euphoria and the P&ID verdict. Now, when I'm talking about the P&ID, I'm talking about the process and industrial development here. Now, recently, there's been a verdict which has actually been discharged in favor of Nigeria. Now, as Nigeria continues to enjoy its court verdict against the Process and Industrial Development Limited in the protracted P&ID case versus the federal government of Nigeria case, the federal government should carefully, I'll put it in that way, put it in place to make sure that there's a framework to prevent the nation from being similarly ensnared in legal processes bereft of due diligence. Now, on the 23rd of October 2023, the Business and Property Court in London, presided over by Justice Robert Knowles, officially ended the enforcement of the $11 billion suit initially awarded to P&ID on January 31st, 2017. Now, by the Law Court of International Arbitration, the LCIA, ruling that the arbitration awards were awarded by fraud, and that the manner in which the award was awarded, let me put it that way, or procured, was contrary to public policy. Now, the roots of this legal tussle can be traced back to January 2010, when the then President Umar Musa Yar'Adua administration entered into a 20-year agreement known as the Gas Supply and Processing Agreement to refine natural gas for boosting Nigeria's electricity grid. In any case, by August 2012, the agreement unraveled as the P&ID failed to produce the expected outcomes. In addressing reasons for its failure, P&ID accused Nigeria of erring to make available the required gas supply for the project. It subsequently took legal actions, claiming a breach of contract against Nigeria. Now, it won the award outright against Nigeria, but initially the arbitration award was $6.6 billion. Now, these figures keep ringing in my ears. Where are all these figures coming from? But yet still, there's no feasible evidence when it comes to advancements within Nigeria. Now, moving on, the arbitration award was $6.6 billion, but the award later summed up to $11.5 billion. Now, as of date of the verdict, which was due based on interest. Now, in any case also, the enforcement of the awards was brought to a halt by Nigeria for obvious reasons, because the figures were quite alarming. During the Goodluck Jonathan administration, the Ministry of Petroleum Resources actually appointed Mr. Bayo Ojo, a former Attorney General and Justice Minister, as a party-nominated arbitrator to constitute the arbitral tribunal for the purpose of settling the judgment debt. By the time the sum of $850 million, now this is hundreds of millions we're talking about, no longer units or tens of millions. Now, it was finally agreed upon that as the term of settlement in May 2015, the Jonathan administration was on its way to power. Rather than pay the agreed sum, the Jonathan administration astutely pushed the matter to the incoming administration, which of course was the Buhari administration. Now, under the Buhari administration, several meetings took place in the instance of the former Attorney General of the Federation, and this was by name Justice Minister Abubakar Malami. Now, on the negotiated settlement of the judgment debt. Now, however, it later came to the knowledge of the former Vice President Yemi Osinbajo, who was the Deputy Vice President to Muhammad Buhari, that in June 2018, the entire P&ID contract was tainted by irregularities. Because these figures are well down to alarming. It's enough to raise eyebrows and drop jaws. Now, consequently, Nigeria subsequently filed an appeal against the enforcement of the awards during the hearing of the appeal. Now, Nigeria also argued that there was substantial evidence of the fraud in the contract and the arbitration awards procurement. It prayed the courts further to set the award aside, highlighting some individuals involved in the case were facing trials for money laundering and other corruption charges. Now, in his ruling of 23rd of October 2023, just last month, Justice Knowles not only concurred with the arbitration awards, which were obtained by fraud, but also found that the manner in which they were procured was contrary to public policy, which I actually said earlier on. Now, although Nigeria secured a legal victory in the case, thereby saving a large sum of $11.5 billion that would otherwise have been paid as an arbitral award to the country, the government should ensure that the P&ID scam is not repeated. It doesn't surface or raise its ugly head again, because the scam has exposed the harm official corruption may be causing within a nation. Now, pilfering government funds or assets by public officials cannot be a statecraft in Nigeria, which ought to perpetuate. Because as Justice Robert Knowles rightly put it in his judgment, I say, and I quote, according to him, this case has also sadly brought together a combination of examples what some individuals will do for money, driven by greed and prepared to use corruption, and giving no thought to what their enrichment would mean in terms of harm for others, which is quite selfish. I would give my explanation to that quote. He has actually stated that officials are actually selfish. Now, as I have observed, I would rightly say that the P&ID scam is a wake-up call for the government of Nigeria to muster political will to go after other similar cases in which some Nigerian officials have, hurriedly traveled overseas and made up arbitration awards they are trying to enforce against Nigeria. If you will recall, we have the Ajaokuta steel, which is on the side. We have the Panama Papers of some years ago, and the list is endless. Now, the Abacha loot is also there, whereby foreign countries just disburse our looted funds towards pocket money, and it's quite sad. Now, before I draw the curtain of today's episode, P&ID scandal ought to make the government checkmate the wild consumption of public assets overseas. Nigeria actually has exhausted so much monetary and human resources in defending the P&ID. The CBN, the Central Bank of Nigeria, as at that time, was made to deposit $200 million in court in 2020. At a time, the former CBN governor, who is currently embattled, and reports making the rounds is that he has been discharged on bail. He had hired fresh British attorneys to represent Nigeria at a colossal professional fee. You could imagine the exchange rate as at that time. Now, the CBN, as we speak, consumed about $40 million on legal services on that same matter. Now, the beginning and key parts of the terms and conditions of that agreement were actually obscure, as identified by Justice Knowles. The Ministry of Finance, the Attorney General of the Federation, and the Presidency seem not to be associated, as we speak, with the contract supervision, which is very, very important. Now, beyond reveling in the injection of confidence from the P&ID contract case victory, which Nigeria is currently savoring, Nigeria must now carry out consistent contract practices and a national arbitration policy, because the repetition of policy shifts and agreement inversions by successive Nigerian administrations constitutes a significant national harassment or embarrassment. Because aside from corruption, which is actually gracing the day of the government, the P&ID scandal occurred due to administrative breaches, if we will see that obviously, and capacity deficits among the Nigerian officials associated with this contract during the contract agreements or contract talks. Consequently, in furtherance to that, to ensure that the government officials entrusted with decision-making power show areas of strong sense of responsibility in the future, because they are not going to be there for life. Other people will still come on board and build on what they met on ground. The government should also put in resources in building the capacity of associated with such contracts and management. These include providing trainings, not just locally, but globally, to make sure that they are credible enough for business practices globally in negotiation skills and contract agreements. I think you are the viewers who buy into that. And most importantly, before going into the future potential global contracts, Nigeria must conduct thorough due diligence on potential partners, authenticating the validity and monetary capacity of these organizations involved. Because some will just come with rubber stamps and all sorts of doctored pens and papers or documents, which might appear convincing, but in factual sense, they are not. And lastly, the government ought to also review and update existing regulations and guidelines connected to contracts and peaceful accords, so as to guarantee that legal frameworks are robust and provide mechanisms for holding those who actually engage in fraudulent activities are actually held accountable. And it shouldn't be a case of, upon when being held accountable, there's a plea bargain on ground to let them go scot-free. No, it also needs to be reviewed. I'm Odiawa AI for Veegil Media, and the show has been Viewpoints, where we discover perspectives and embrace dialogue. You will do well to subscribe to our YouTube channel and follow us across various social media platforms. And don't forget to download the app on the Google Play Store and the Apple App Store. Thanks for watching.